Good day, liberators and fellow South Africans. The purpose of this video is to give everyone feedback on our progress with our court challenge to review all the decisions relating to the approval of the final registration of several COVID-19 vaccines. All these approvals and final approvals have been conducted behind our backs in stealth, and Liberty Fighters Network has approached the High Court in Pretoria to request that all those decisions are reviewed, and if they're found to be invalid, to set them aside. Now, what has happened was that, let me quickly go to the application. This is the court papers that we have issued on the 3rd of June. We are seeking that all the decisions to approve and register any COVID-19 vaccine in terms of Section 15 of the Medicines and Related Substances Act of 1965 are reviewed, declared unconstitutional and invalid, and set aside. Now, what has happened was that the South African Health Products Regulatory Authority was served with the papers by the sheriff, and let me show you this as proof. There's the return of service by the sheriff that on the 17th of June at 10:20 at their offices, a certain Mr. Tebogo Kalembu, which is a project manager, have received these papers for the South African Health Products Regulatory Authority on the 17th of June. Now, they were supposed to file their record within 15 court days thereafter, reckoned from the 17th of June, and also to file their notice to oppose. And both they did not do. So, in terms of the rules of the High Court, the uniform rules of court, Liberty Fighters Network were entitled to proceed to enroll the matter on the unopposed roll for hearing. So it means that it's undefended, it's unopposed. So we've proceeded with that process. We, in fact, got a hearing date for the 31st of October. Yeah, it's quite far away, but well, it's a court date that we can at least confirm. And suddenly they woke up, and then they served us with a notice to oppose. Let me show you this. Now, here they have opposed it, notice of intention to oppose, only on the 25th of July. Now, so there's the attorneys with the further details of it. And so they totally out of time. They did not adhere to the rules of court. So there are authority to say that if you don't follow the rules under these processes, and if you don't request condemnation from the court, then it's considered that your papers are not before court. So we are well entitled to still proceed as if this matter is unopposed. So what we consequently done was that we have then lodged and served them with a Rule 30A1 notice, whereby we are telling them that they have failed to comply with the provisions of the rules, and it's Rule 65D1 and 53(1)B of the Uniform Rules of Court, and that unless the respondent, which is the South African Health Products Regulatory Authority, remedy its aforesaid non-compliance with the rules by delivering the records and the condemnation application for late filing, the applicant's intent, after the lapse of 10 days from the date of service of this notice, to apply to the above court for an order compelling the respondent to comply. So this is typically a stalling tactic from their side. Because usually, if I was not a legal, or if I was a legal practitioner, they would have just said, oh no, it's fine, and then 15 days from here on, from the date of delivery of the notice to oppose, they will have to file their records, if ever. But now, by having served them with this notice, in terms of Rule 30A1, they must do it within the next 2 weeks. Otherwise, they are further barred to continue, notwithstanding that we are continuing with the process to hear this matter unopposed on the 31st of October. They are then prevented from actually providing their record. So they are now put on terms that they are compelled to do so. So that is one of the advantages to proceed with cases without attorneys, without a legal team. Because if I was a legal practitioner, this would never have been done. And my colleague, my brother or my sister in the fraternity would have been given thumbs up to say, okay, we will just allow this as if you have legally complied with everything. But that is not the case. So, people, we are indeed proceeding to challenge these registration of various. According to us, there were 5 vaccines that were finally registered by the South African Health Products Regulatory Authority at a time when the World Health Organization has not even completed the full clinical trials of any vaccine anywhere in the world to be safe and ready for full implementation. So how the South African Health Products Regulatory Authority managed to register, in terms of Section 15, which is a final registration, at least 5 of these so-called vaccines, they need to tell us. We need to know how they managed to finalize their processes much quicker than even the World Health Organization did. People, this is just a short summary of what we're busy with. We will keep you updated with the progress in this specific matter. Please remember to subscribe to our channel. Share this if you like this, like it, and also consider joining us as members on this channel. Stay safe. God bless. Until the next time.